Okay, I'm really pleased that Kerry Rees is in the studio today. Kerry is a partner and patent attorney at HGF. They're a leading law firm specialising in intellectual property rights. They offer a comprehensive range of services, including patent, trademark and design attorney services, as well as IP litigation, transactional IP, commercial law, data protection, due diligence and IP advisory work. And he may be a familiar face to many of you, as he is also our resident IP columnist. Kerry, welcome to Protein Production Technology International.
Hi, Nick. Thanks for the introduction, and thanks for inviting me along today.
It's an absolute pleasure. Now, Kerry, given your experience at HGF, I'm curious about what initially sparked your interest in food tech. What drew you to this particular area of innovation?
Well, my background is in biochemistry and molecular biology, but I've been involved with food technology on the IP front since day one of my career, really, must be 23 years ago now.
Right.
I used to work on patents to do with astaxanthin, which you might know is a compound that makes a carotenoid. So it makes things like salmon, fish, meat pinker. And I was working on that for many years, and new enzymes used in food tech. But then that moved into precision fermentation over, say, about 10 years ago. And then more recently, I was fascinated by cellular agriculture and an advocate for sustainability and sort of food security for the future. So I've been watching that development for many years now as well.
Yeah, and there's lots of developments on that front. So let's start with the basics, Kerry. When we talk about patents, what's the core purpose that they serve?
Well, I guess the core purpose, sort of in a legal sense, is think of a patent as a negative or monopoly right. So it doesn't give you the right to do anything, but it gives you the right to exclude sort of unauthorized third parties from dealing with your inventions. So if you have a patent that covers a new development you have, then you have the right to exclude, say it's a claim to a product, you can exclude third parties from making or using or selling or importing or keeping the products, so generally dealing with the product in any way. Mm-hmm. So that is the prime sort of core purpose that they serve. So it's like you have a piece of land and you've put a fence around there, and that's your patent claim that excludes people from coming onto your land. But then there are other benefits that derive from that. You can, as a consequence, you can get security for your market share. You can help. The IP is useful to attract investment. People will external VCs, for example, will want to see a reassurance that their investment is protected, and your patent can help you do that. And it's also good as a marketing tool. It gives an indication of some sort of innovation going on, and that can be used to market yourself. And it's used to leverage deals with to get licensee and licensees on the hook and get people and revenue from that way as well.
Mm-hmm. So let's imagine I'm a startup just setting out on my adventure. How can I determine whether or not a patent is necessary for my business?
Yeah, so one of the first questions I ask people, new clients, startup businesses in particular that might be thinking about patents is why? Why would you need a patent? And really that question is sort of go back to the absolute fundamental of your business. What are your business aims and what is your business plan? And do you have an IP strategy in place that aligns with that? So think about using the IP to achieve whatever aims you have in your business. You might need IP and patents in particular if your competitors are innovating, and they're likely to be copiers that you'd want to stop. Are there other competitors in the marketplace that have their own IP? So you might want to, you might need to take a license for them, for example, to get into the business that you want to do. But you have your own IP to sort of leverage and get a deal with them. Are you needing external investment to reach the various milestones that you have? And if you do, then investors do look for IP being in place to have some reassurance that their investment is protected. So if you're in that kind of business where those factors play, then it might be that you need IP is something that you should consider.
So it's not only to protect your own innovations, but it could actually be a tool to use to, um, establish collaborations. If
Absolutely, yeah. It
applies.
brings licensees in, and you can do deals on the based on the IP that's underpinning some technology that's in the transaction.
Hmm. Now, timing it's crucial in the world of startups. At what point should food tech companies be considering their intellectual property strategy?
Well, from the outset, definitely from the time of drafting the business plan, think about whether IP is likely to be important. And of course, we're not thinking just of patents, but trademarks, design rights, there'll be copyright and trade secrets. There's a wide plethora of different rights to consider. But it's much better to have your IP strategy in place when you draft the business plan, so then you can align one with the other. It's more effective. Your IP is likely to be more effective and targeted if it's aligned with the business and the aims that you want to achieve. Things like educating people in your company about not disclosing inventions before you consider whether patent applications are to be filed. Having everyone engaged from the board but also across to researchers, so they both pull in the same direction. And I guess the first thing to assess is the nature of your business likely to result in a development that's technical in nature, because some things are just not patentable because they're excluded from patentability. Other things are not technical in nature, so then probably wouldn't serve as for a patent application. So think about the service or the product you're providing. Are you solving some problem that exists? And is the solution that you're proposing, is that technical in nature? And if you can sort of answer those questions with a yes, then you might benefit from a patent application. But have those thoughts early on in the process, because companies often come to IP late, and by that stage there's been disclosures of their inventions and their business and the things that the technical developments that they're making, which means that they might not be able to obtain patent protection, and once that's disclosed, then it's gone forever possibly. So in answer to your question, what timing is crucial, then yes, at the outset when you're setting up your business.
Mm-hmm. Now, for startups and investors, I guess you're not only working with startups, but you're probably conducting due diligence on behalf of VCs. It's essential to understand the different types of patents relevant to food tech. So can you simplify some of the key options? I know you've mentioned, design rights and trademarks.
Right. So patents protect, which would probably be the most relevant for food technology companies. So companies that have innovative solutions to a technical problem, then we're looking at patents. And you could have patents for food tech in particular, would be looking at compositions of matter claims to processes, processes of manufacturing a new food ingredient using sort of a microorganism, new enzymes that might be involved in that. Then you're looking at like cellular agriculture. Let's think about that. We'll have the stem cells that are used, the muscle cells, the sort of the tools that are used to genetically modify those cells to make them grow faster, to make them sort of phenotypically sort of stable over multiple divisions. We'd have things like the cell culture media. You'd have the bioreactors and architecture and changes to new sort of designs of architecture of these bioreactors to allow cells to proliferate quickly. So those are the patents. There'll probably be designs involved in sort of apparatus that you might develop, new machinery. Could have patents and designs, and then trademarks are protecting the brand. Your sort of position in the market, if the brand and your name or your logo is distinctive and important, then that's something you should think about protecting as well. There'll be trade secrets involved. Some things are not going to benefit from patent protection, but are still quite important, like know-how and things that your researchers know how to tweak a particular apparatus to make it work well, and that's sort of an optimized conditions that you would end up with a claim that would be so narrow in a patent that you wouldn't, it would easily be worked around. So you might want to keep those things secret. But then there's a load of discussion about trade secrets and the pros and cons of those as well. So it's a blend of different rights that any sort of innovative company would end up having.
Well, we're going to talk about trade secrets in a second, but building a strong IP portfolio is vital for any food tech startup. So should they prioritize patents, trademarks, or a combination? What's your recommended approach?
Well, for patents, there's this requirement that your invention needs to be new and inventive. So new means not disclosed in any way before, so not published, not discussed, not sort of presented upon or anything like that. So there's a pressure there to file patent applications before you disclose to the public. So naturally the patent application comes first. But then the trademark is protecting something else. Nothing, you're not going to be disclosing the sort of technical developments if you file a trademark application. So I don't think it's a question of what should I do first, second, and third, but all of these things need to be fitted in a way that makes sense with a business plan and where you are in your technical development sort of thing. Do you have enough data yet to support your patent application? But also, is there a pressure on you to disclose your invention in a publication, for example? So there's a balance between two. I don't think there's an answer of what should come first, but I suppose patents might come first, and then trademarks a bit more down the line if you developed your brand. Designs somewhere in between, probably, because they're a bit more lenient. There are certain grace periods for designs, and design would probably protect a sort of piece of apparatus or kit that you might need to develop more and understand what the final apparatus will be that you sell, or packaging or something like that, and that might be further down the line.
When it comes to IP, what would you consider the most crucial element for startups to get right? Well, I guess you hear a lot of horror stories. That's a word.
What is crucial to get right? I'd say, well, I've talked about the business plan, and that is crucial because there are people that file patent applications because they think that would be a sensible thing to do when there's not much thought gone into have you filed the correct patent application? Is it framed in the right way? Is it going to achieve what you want to achieve in terms of attracting licensees or excluding people from the market? So not having an IP strategy and a business plan is at day one is a problem. Then if you're talking about more specific things, then it's very unforgiving, the filing and drafting and prosecuting a patent application to grant. So if there is mistakes made, there are some ways around that, but it can be fatal sometimes if you don't have, say, the correct fallback positions in your application, such that you need to amend down to get novelty. If you don't have the correct data or enough data to support your patent claims, that can lead to problems down the line, because once your patent application will ultimately be published 18 months after filing, and then any subsequent things you file in the future will count, your original application will count as prior art against you. So you need to get it right the first time. So that means having engaged with professional sort of patent attorneys that are well versed in that food tech field, that know the technology well, that are used to drafting these patent applications in this field.
I guess it's similar to filing dossiers for regulatory approval. You've got to get that document right, otherwise you could be open to opposition from competitors. I mean, is it the same as trademarks, where it's published and then there's a period of opposition open?
There is, for trademarks, yes, but also patents, yes. So European Patent Office, you have your patent grant, and then there's a 9-month period whereby third parties can oppose you. And also, post grant, if you try to enforce, or somebody will try and say that your patent isn't novel or isn't inventive or some other grounds, then it's going to come under attack. So having a really robust application from the start. So when you draft your first application sort of early, the first thing you do is it's important to get that right.
Hmm. I guess it's quite challenging, isn't it, for startups because they have that 18-month period before they are granted their patent, but their technology may have evolved in that time. So do they have to go back and revise it? It's just
Yeah, sure. So in terms of sort of a filing strategy, a typical one would be to file your application, say, in the UK first,
Mhm.
and then you'd have 1 year to add developments to the application. You maybe get a search done by the UK IPO. So then on the 1 year stage is an important time that you decide that's the cutoff point of adding new developments to your application for that particular invention. But then if you wanted, people talk about global protection. I doubt very much that you would ever, as a startup, see global protection in every country because that would be sort of prohibitively expensive. But you might file a piece, something called a PCT application at the 1 year stage, and that would sort of act as a holding pen where you can develop your technology a bit more. And then that's sort of assess the commercial viability of your invention before then, sort of 18 months or so later. So you have the first year, then another 18 months, and then you could enter the various countries around the world that you want. You're unlikely to get a patent granted in 18 months, much longer, but it's always a question of reassessing, where is my invention going? What are my business aims now? Is this patent application still worth having and spending the cash on it, or has the business changed such that the process that we initially covered is changed so much that it's a new process or a new product that we're making, and we might need a new patent application, start the process again. So it kind of keep auditing and checking what your portfolio is and what you're covered in your original application. And companies should do that anyway, those that are developed, because you have maintenance fees going forward, and this can be escalate costs quite quickly. So just keep an eye on, is your IP still working for you, and is any obsolete, and you can just drop it. So then and save some cash that way.
Mhm. Are there instances where you might advise a startup to keep an innovation secret rather than filing for a patent?
Yes, the trade secrets. So we talked about that a while ago. So there are some, I wouldn't say innovate, some developments that are just not technical in nature. So they wouldn't benefit from a patent application. So let's think some sort of a mathematical model, like an algorithm or something like that, where you look at sort of consumer data. That's I'd speak to an electronics attorney, but that might be borderline protectable, and you might want to keep that kind of a secret within the company. There are some things that are technical, like a sort of optimization of a process, say, but the claim you would have would be so narrow that that might be easily worked around and not worth protecting. In those cases, there are something called trade secrets that companies sort of exploit, and there are certain sort of things you need to do in the company for a piece of information or a technical sort of feature to benefit from a trade secret. But the problem with trade secrets is they have to remain secret. And of course, there is a risk that things don't remain secret. People leave businesses. Disgruntled former colleagues will talk about what they did in their previous company. You'd have restrictions, I suppose, in contracts, but there's, how far can you take those, and what is just sort of common knowledge and what they developed themselves, and can they take that forward? So trade secrets might be cheaper and seem a good thing for people that don't have very much cash to file patent applications, but there are shortcomings in that there's a risk that things won't remain secret, and then suing somebody for breach of trade secrets is quite an expensive task to go through.
Yeah, well, we've just seen that with not quite for trade secrets. We saw that with Meaty, but we've just seen that with Motive,
Yeah,
Foodworks, and Impossible,
yeah,
haven't we? So that went
yes,
on for a good
absolutely.
few years.
Yes, yes. That wouldn't have
Um,
been cheap. Yeah.
no, no, I'm sure it wasn't. Now you mentioned you touched on the sort of global nature of patents and old proteins as well. Are there any specific regional considerations to keep in mind?
Um, Generally, without getting into too many specific things, there are intricacies from country to country, but the idea of novelty and obviousness is sort of harmonized around the world. But there are other things like data, for example. So you need an amount of data in your patent application to support the claims that you're filing. So if you say that something has a technical effect and solves a problem, you need to have data in your application to back that up so that you can refer to. And to a greater or lesser extent, depending on from country to country, whether you can add data, I mentioned this 1 year cutoff point, whether you can rely on data generated after that point varies from country to country. So that could be something to bear in mind at the early stages when you're drafting your application. You need to think about what countries you actually want to protect in ultimately. So where are you manufacturing? Where are you selling? Where are your competitors? And at the very first stages, think about, well, do I have the necessary data in the application to be successful in those countries and get a patent granted there?
Mhm. Now, you mentioned that patenting can be expensive, especially gets to that litigation stage. So what strategies can startups employ to manage their costs a bit better associated with securing and maintaining their IP rights?
So yes, it can get very expensive, but I would say go back to the when we started this conversation is to have the IP strategy aligned to the business plan, so you don't draft and file applications to things that are just not gonna be relevant. Be selective in the things that you're trying to protect. The important things that underpin your business. I would not sort of be cost conscious, but I wouldn't sort of try to do drafting on a shoestring because you need to have a robust patent application at the starting point, because that forms the sort of the foundations and the roots for how that application will develop and how successful you will be. And then if you need to license it, there'll be due diligence. If you want to attract investment, if you want to, take action against somebody, it all comes back to that original application and the application you filed at the 1 year stage. And is that in good sort of, can it be kicked around? Is it robust? So investing some cash at early stage is important, but focus the cash on the IP that's really going to work for your business. Don't file for everything, because you will spread yourself too thinly, and you'll end up with a load of patent applications, none of which are can withstand attack ultimately, and can go through due diligence and those kind of things that will happen if the IP is important and should withstand those sort of scrutiny in the future. Also, if you already have some IP, and keep your eye on it and keep assessing whether that IP is still relevant. Is it obsolete? And if it is, then drop it and save some cash and focus your budget on new things.
I guess that's one pitfall. I mean, what are the other fatal mistakes that startups should avoid when it comes to intellectual property?
Filing too early I'm talking about patent applications now. So filing too early is never a good idea, because of you need to have the right amount of data that will support your patent claims. But then filing too late is also not good enough. It will fail because you've disclosed it, or there's been a presentation or something like that. So there's a balance there, and a pressure one way and a pressure the other that needs to just be sort of managed sensibly. And and having a run up as well. So drafting patent applications can take quite, significant amount of work. So trying to do those really quickly, you can be done, but you'll end up with a poorer product than thinking about it over a length of time and having a good run up at it to get a good quality outcome.
And I guess that's why recruiting the right IP expert is essential. So what should let's take your HGF hat off for the moment. What should startups look for when selecting a guide for this process?
Well, I would say to go to a patent attorney, and I would say that, wouldn't I? But I genuinely recommend that you do, because there are so many pitfalls and things that can go wrong. Like, you do need expert guidance in drafting and filing patent applications. Go to qualified patent attorneys. So Chartered Institute of Patent Attorneys keeps lists of patent attorneys that are qualified, but also look for patent attorneys that have expertise in that field, so are specialists in food technology, in cellular agriculture and precision fermentation, because it's particularly drafting patent applications is such a sort of focused and technical discipline that you need people with expertise to do that.
Well, Kerry, it's been absolutely fascinating hearing from you again. I shall look forward to seeing you in, 5 or 6 weeks until we're in Amsterdam for the future induction. And we'll be hearing from you once again out there. Thank you very much for your time. It's been an absolute pleasure as usual.
Thank you, Nick. See you soon.
Take care.